Hi, this is Dan Smith of DPS Legal Counsel. Welcome to today's video. Today I want to talk about the new final Stark rule that CMS published on December the 2nd, 2020. There's a lot in this final rule, but one thing in particular I want to talk about today is how it impacts compensation formulas that may be in your group practices agreements among your members, how you are going to be sharing the profits from your designated health services. Now, without going into a lot of detail about what's a group practice and how a group meets the in-office ancillary exception under Stark, I just want to kind of focus on the changes that are made by the new final rule dealing with the sharing of profits, overall profits from a group's designated health services. Now, if you have a group of more than two, at least two, and fewer than 5 members, either 2, 3, or 4 members, what you have to do under this final rule is just take the overall profits from all of your designated health services, and if you're going to share them, you can share them in any methodology that doesn't take into account the volume or value of referrals, but all the physicians would need to be treated the same under that formula, so that you could not take a couple of them and base it on productivity, general productivity, and the other couple and base it on per capita distribution. You would have to take your overall profits from your designated health services and then to share them under some methodology that's the same for all of your members that are getting a share, but that doesn't take into account obviously the volume or value of referrals for those designated health services. Now, let's say you have a larger group practice. Let's say you have a group practice of 15 physicians in your group, and let's say it's a multi-practice group. You have 5 internists, and you have 5 surgeons, and you have 5 dermatologists. And let's say that you would like to have the shares of each of those pods, those different specialties within your group, receive their share of designated health service profit in a slightly different way than the other doctors in your group practice. For example, you may want to provide that the 5 internists in your group get a share of designated health services based on a pro rata share, so that there are 5 of them. Each one will get 1/5 of the profitability that's allocated to that group, that pod within the group. And let's say the dermatologist, you want to base it on their RVUs, or their general productivity during the year. You can do that. And then the third group, the surgeons, you may want to do that based on even a different criterion. Obviously, none of the criteria that you use can be based on the volume or value of referrals that a particular physician makes to the group for those designated health services. But as long as it's not volume or value based, then you can use a different methodology for each of those 3 pods: the 5 internists, the 5 surgeons, and the 5 dermatologists. But what you have to do is you have to take into account, you look at all of your aggregate profits from all your designated health services. Let's say you have imaging, and you have clinical laboratory services, and you have durable medical equipment profits, and other things that are designated health services, but you have a number of different categories of designated health services. One thing you cannot do is you cannot allocate service by service. So you can't give all the internists the clinical lab designated health service profits, and all the surgeons the durable medical equipment profits. You have to look at the profitability across the board for your group for all designated health services that your group provides. And then you can allocate by pod a different methodology, but it has to be based on the overall profits for all of your designated health services. So let's say that you have 15 then, like I said, 15 different doctors, but in different groups. As long as you have a pod of at least 5, you can allocate in a different method from another pod. Now, this new rule that kind of clarifies what makes up a group practice and how designated health services are provided doesn't go into effect by its terms. The effective date of this change in the rule is not until January the 1st of 2022. So you have basically a year to make sure and review your compensation formulas in your group practice agreements and make sure that you're going to be compliant going forward with Stark and with this new final rule. Now, it does provide in the final rule that this change is a clarification. So I would suggest that it's a good idea to go ahead and make this change if you need to, if your agreement is not compliant with the final rule, to make this change as soon as possible, because the rule does say it's a clarification of the position that the CMS already holds. So at a minimum, I think it's a good idea for, if you are dividing profits from designated health service in your group on a service basis, so that some get profits from a particular designated health service like imaging, and another group gets it based on durable medical equipment, and some get it on clinical laboratory services. I would suggest you need to make changes as quickly as you can to your agreements to take away the ability of your group to divide profits based on service categories. Do that as soon as possible, because like I said, the final rule, even though it says it's not effective until January 1 of 2022, does indicate that this is a clarification. So sooner rather than later on making the change with respect to not dividing based on services, what's often called a split pool. But as far as the different pods of at least 5 physicians within, or a component of at least 5 physicians within your group, and having a different methodology for allocating the overall designated health service profits to that particular component, that's something that, again, is not going to be effective under the terms of the new final rule until January the 1st of 2022. So this gives you some time to review your agreements, but this is definitely something, if you have a group practice, and particularly if it's a multi-specialty group practice, and you want to divide your designated health services differently among the members of your group based on their specialty, if you can meet this requirement of having at least 5 physicians in that particular component that you want to treat differently as far as the method of dividing it, then this is something you need to look at and make sure you can have your agreements comply with the new final rule. Okay, I hope this helps. There's a lot to be unpacked in this new final rule that CMS has put out on the Stark Law, and I'm going to be talking about it a lot this year because this is something that is important for all physicians who are in group practices to understand and make sure that their agreements are compliant. Okay, I hope this helps, and we'll see you again next time.